Move to dispense with the reading of the roll of members.
Second. It has been moved and seconded that we dispense with the calling of the roll. Any objection? There being none, the calling of the roll is dispensed with.
Thank you once again, Mr. Chair. Mr. Chair, move to dispense with the reading of the approval of the minutes of the organizational meeting held last August 13, 2025.
There is a motion duly seconded that we dispense with the reading of the minutes of the previous meeting and for the approval of the same. Any objection? There being none, then the motion is approved. Comsec, can you acknowledge the members present for today's hearing?
Thank you, Mr. Chair. Good morning, ladies and gentlemen. For our meeting today, we have with us, of course, the chairperson of the committee, Honorable Jonathan Keith T. Flores. We also have our vice chairpersons, the Honorable Joseph Jojo L. Lara and Honorable Celso G. Regencia. Also with us is the Honorable Dennis Alden B. Almario, the Honorable Jose Manuel Shell Jokno, and the Honorable Elijah Rumbawa San Fernando, who was here a while ago. And for our resource persons from Department of Justice, we have with us Undersecretary Jesse Hermogenes T. Andres, Attorney Eliza Andrea Adorna, and Senior Assistant State Prosecutor Mary Jane Sistat. Okay. Also with us is Assistant State Prosecutor Marjorie Castillo. Please acknowledge if you are around. There you are. And also Assistant State Prosecutor Arnold Veray. From the Dangerous Drugs Board, we have with us Secretary Oscar F. Valenzuela, the chairperson, ASEC Ferdowsi B. Masnar, the Deputy Executive Director for Operations, and Ms. John Mee Oba, the Head Executive Assistant, Mr. George M. Bautista, the Development Management Officer, and Mara R. Poblete, Administrative Officer 2. From the Philippine Drug Enforcement Agency, we have with us Assistant Secretary Israel Ephraim T. Dixon, the Deputy Director General for Administration. You are, please acknowledge. Yes, you are here. And Director Wardley Hitalia, Director for Plans and Operations Service. Attorney Francis Del Valle, the Head of the Legal and Prosecution Service. Director Emerson Margate, the Director for Intelligence Service. Director Agnes Mandap, Director for Compliance Service. And Director Angela Salvador, Director for Laboratory Service. From the Philippine National Police, we have Police Colonel Fitz A. Macariola, Police Major Jinson Madato, Police Colonel Rani Hatchuela of the CIDG, Police Major Christine Azuma, and Police Colonel Ruel Lamiing, and Police Colonel Ella Cristina Colangen of PDEG. Thank you. From the National Bureau of Investigation, are you here now? NBI. Sir, we have invited the NBI and they confirmed their attendance, but they are not yet around. From the Department of the Interior and Local Government, we also invited them. The Prosecutors League of the Philippines, represented by Attorney Armando Cavalida. From the Bureau of Corrections, represented by Attorney Cesar Anthony Solis. Are you around? Not yet. From the Commission on Human Rights, Mr. Erwin M. Caliba, the Chief of the Legal and Legislative Division, is around. From the Integrated Bar of the Philippines, from the Kapisanan ng mga Broadcaster ng Pilipinas, Attorney Reggie Jularbal, the Legal Counsel. That's all for now, Your Honor, Mr. Chair. Thank you.
Thank you, Comsec. For today's meeting, we have three measures, no, seeking to amend our 23-year-old Dangerous Drugs Act. And while waiting for our authors, instead of making them first present their sponsorship speeches, we would do it the other way around. Now, let's go with position papers first for to save time din. No? I don't want to keep you guys waiting. Para at least let's keep the ball rolling, since alam ko naman na medyo mahaba-haba itong provisions that we will be discussing, and most likely we will end up with a technical working group. So might as well go with position papers now, so the members present could also post their questions if there be some. So now let's start with. Oh, did we already acknowledge the members present? Our members?
Yes.
Okay. Sorry. Oh, yeah. We would also like to acknowledge the presence of Congressman Pimentel of the 2nd District of Surigao del Sur. No? So, we would now like to hear from, you don't have to read your entire position paper, but if you'd like to highlight just certain portions of your position, then that would be best. From the Dangerous Drugs Board, we have Secretary Valenzuela. Sir?
Good morning to the chairman and to the honorable members of the House Committee on Dangerous Drugs. I am Secretary Oscar Valenzuela, the chairman of the Dangerous Drugs Board. And on behalf of the Dangerous Drugs Board, I am pleased to join today's discussion on the proposed measures to amend Republic Act 9165 or the Comprehensive Dangerous Drugs Act of 2002. At the outset, let me thank the Honorable Chairman of the committee, Congressman Jonathan Keith Flores, for the opportunity to speak before everyone, this group this morning. Please allow me also to express our gratitude to the House of Representatives, especially to this committee, for including in its proposals several proposals to amend Republic Act 9165 as part of its legislative agenda. This manifests the committee's firm resolve to ensure that our anti-drugs law address the evolving drug situation in our country. In the past Congresses, many proposed provisions for possible inclusion and exclusion were discussed in the process of amending Republic Act 9165. Each item brings with it important arguments that can contribute to the effective implementation of drug demand and drug supply reduction priorities of the anti-drug campaign. However, the Dangerous Drugs Board's utmost concern is the need to align the country's anti-drug law to the thrust, direction, and priorities of His Excellency, the President. Since 2022, the President has emphasized the shift of his administration's drug abuse prevention and control agenda. The effort is now focused on sustained enforcement, such as addressing street-level pushing. Equal priority is also given on treatment, rehabilitation, prevention, and community-based interventions. As an interagency body, tasked by the President to formulate policies and develop strategies on anti-illegal drugs, it is the Dangerous Drugs Board's primordial role to ensure that the President's trust, guidance, and directions will be institutionalized by way of laws. Thus, our inputs to the legislative agenda to amend Republic Act 9165 contain important points that will align the current administration's trust and ensure its inclusion or integration in the bill that aims to amend the existing anti-drugs law. Your Honor, ladies and gentlemen, we have come a long way in ensuring that the enhanced Philippine anti-illegal drugs strategy remain effective and responsive to the demands brought about by evolving landscape of our domestic drug situation. Guided and inspired by the President, we have aligned our approaches to the human rights and public health-based approach, which also envisioned to be integrated and incorporated in our Dangerous Drugs Act. This alignment will reaffirm the Philippines' commitment to international and regional drug control treaties and obligations. Indeed, we're very confident that our legislators can make this happen. Your Honor and members of this committee, it is also worth mentioning that at the end of this month, we are scheduled to join a mission to the United Nations Office of Drugs and Crime in Vienna, along with other countries, at the Commission on Narcotic Drugs meeting to affirm our commitment to the international and regional drug control treaties and obligations. Thank you, Mr. Chair.
Thank you, Secretary. All right. Next, we have the Philippine Drugs Enforcement Agency, PDEA.
To the Honorable Chairperson of the House Committee on Dangerous Drugs, Congressman Jonathan Kitty Flores, distinguished members of the committees, ladies and gentlemen, good morning. On behalf of the Philippine Drug Enforcement Agency, I extend our sincere gratitude for the opportunity to present our views and recommendations on the proposed amendments to Republic Act number 9165, also known as the Comprehensive Dangerous Drugs Act of 2002, as outlined in House Bills number 74, 371, and 2756, and House Resolution number 50, which commends local fishermen who voluntarily surrendered packs of shabu found floating in Philippine waters. Republic Act 9165 has long served as the cornerstone of the Philippines' anti-drug efforts, laying down a strong legal framework for prevention, enforcement, prosecution, and rehabilitation. However, more than 2 decades since its enactment, it has become increasingly evident that several provisions are now outdated and no longer sufficiently responsive to the changing dynamics of drug trafficking and abuse. The illicit drug trade has evolved into a highly organized, technologically enabled, and transnational enterprise. Criminal syndicates now exploit social media platforms, encrypted messaging applications, e-commerce sites, cryptocurrencies, and the dark web to conduct their operations. These tools have allowed them to operate with greater anonymity, mobility, and rich-making detection, investigation, and prosecution significantly more difficult. Given these realities, PDEA fully supports a comprehensive and urgent review of RA 9165. We must modernize this law to ensure it remains aligned with contemporary drug trends, technological advancements, and international standards for drug control and cybercrime enforcement. Thank you, and we look forward to engaging with the committee in crafting meaningful reforms to RA 9165. Thank you, sirs.
Mr. Chair,
Vice Chair Rehencia.
I just want to make a query with regards to the operations against illegal drugs. Kasi po, Mr. Chair, sa nakaraang mga buwan, maraming druga na na-recover sa mga mangingisda sa karagatan ng Ilocos, karagatan ng Bataan, karagatan ng Samar, at saka lately sa Zamboanga City. No? So itanong ko sana kung enough ba yung budget natin para sa fight against illegal drugs. Kasi ito pong mga drug activities ay hindi basta-basta ito. This is an organized crime groups na maraming pera. Kasi magtaka tayo, bakit ang daming druga nga makikita sa karagatan, parang sinadya na tinatapon, tapos yung malaking porsyon ay palusutin. Ganun po, sino bang ano doon, si Secretary Valenzuela o yung sa PDEA o PDEC?
Yes, thank you, Your Honor, for the observation, and we really appreciate that the predicament being met or experienced right now by PIDEA is being given attention, sir. We really need additional resources, not only on our campaign against illegal drugs financially, but we have brought this up previously. The additional manpower should also be given due attention, considering that we have a very vast seashores, and we need personnel to man or operate in these areas. And of course, to complement the additional manpower, we need additional resources like the MOEs and other requirements, Your Honor, sirs.
Sa pagkakaalam ko, Mr. Chair, last meeting natin, nabanggit sa PDEA na there are only 1,945 personnel operating across the country. Kunti lang talaga. So, sa ngayon, nung balita na natanggap ko na galing sa Zamboanga ang Shabu, tapos ibuhos doon sa distrito, sa Iligan City, talagang nagano ako, mabuti na lang na disgrasya yung nagdala sa Shabu, which is 67 kilos of Shabu. Ang kasama niya, yung asawa niya at saka yung anak niyang maliit. So, sa atin ngayon sa PDEA, sa DDB, mayroon na ba tayong mga listahan talaga sa mga taong nag-ooperate sa illegal drugs? Kasi kung hindi natin ito masugpo, talagang talamak tayo. Huwag na nating hintayin pa na matulad tayo sa Colombia, matulad tayo sa Venezuela na ngayon binumba na ng Amerika dahil palaging nagpapasok ng druga doon sa United States, galit na si Trump. So kung wala naman tayong kakayahan na ganun, so anuhin na lang natin nga, we will work it seriously. Kasi kung wala tayong budget, no, PDEA, wala tayong budget, hindi tayo wala. Easy lang na ma-bribe yung mga tao natin. Imagine, sabihin, magkano ang sahod mo? Kunti lang. Pagkatapos, ito, 500 million, wag mo na kaming hulihin. Ito na ang 100 kilos, dalhin mo na para sabihin mong nakahuli ka. So, Mr. Chair, ganun talaga ang ngayon. Proliferation of drugs is rampant in our country. Sa naman, sa PIDIG naman, hindi rin sila masyadong makakilos dahil kulang din ang budget. Tapos detached service lang kayo sa PDEA. Right? Kasi kung walang budget talagang prone talaga na ma-bribe yung mga tauhan natin. Imagine, we have 7,641 islands. Pagkatapos, ang PDEA natin is only having a personnel of 1,945 operating throughout the country. Sana naman matulungan sa PIDIG, tapos mayroon tayong listahan upang kahit dandahan, titirahin na yung mga drug lord na kung saan sila ang palaging ng druga. Kasi may information rin ako na ang druga ay niluluto na doon sa high seas, sa malalaking barko. So, paano natin ito, ano ba ang mode of operations na gagawin natin? Bilang isang dating pulis na naging mayor din ako sa Iligan City for 3 terms, ang druga, hindi talaga kung bawat local government unit, yung mga mayors, yung mga governors, ay maglaan ng pundo para anuhin natin yung druga. Kasi kawawa ang mga kabataan natin. Pero para sa akin, hindi rin yung bakal na kamay. Ay, for me, it's better to scot-free the guilty than to hang innocent party. So kailangan patas yung pag-fight natin against illegal drugs. So Mr. Chair, sana maanuhan natin ito. Sabi sa PDEA, they are lacking of personnel, lack of resources. Kung magkuha tayo ng mga personnel, mag-recruit tayo, kailangan may sahod, kailangan may baril, kailangan dagdag ng mga equipment. So with that, Mr. Chair, I hope that one of the amendment of the Republic Act number 9165 is stipulated in this amendment, Mr. Chair. That's all.
Thank you, Vice Chair Rensha.
Mr. Chair, like what the congressman has said, sa Surigao del Sur, nangyari na rin yan sa amin before. Na kami ang nauna sa Caraga. During the time ni General Gilbert Cruz, ang daming bumaksak sa Caraga, sa Surigao, sa Agusan. Nakakuha nga kami ng isang drum, 40 kilos ng shabu. Ang tatak dollar sign. Nakakuha rin kami ng 2 drum ng marijuana. At dito, sa laban natin na to, mahirap talaga kasi pera ang nakasalalay dyan eh. Doon sa probinsya ko, nagbibigay ako ng governor pa ako, nagbibigay ako ng reward sa lahat ng law enforcement ng 10 to 100 to 500,000 depende kung high level ang target. Dapat makausap rin natin lahat ng mga LGUs na magbigay ng reward kasi kulang ang funding ng mga law enforcement agency. At lalong dumadami ang mga street pusher. Kasi ang nangyayari po dyan, una, patikimin, maadik. Pagka wala ng pambili, magnanakaw sa bahay. Pagkatapos niyan, gagraduate na pusher kasi para libre na sila ng tirada. At ang isa pang kinakabahan ko, Mr. Chair, kasi marami silang pera. In Surigao, ang mga drug lords doon ng 20%, tinitira nila para sa mga birador nila. Kasi sabi nga nila na noon, kung nanlaban, bibirahan din natin sila. Ganyan ang nangyayari sa Surigao del Sur. Yung mga informant namin, pinapatay din nila. So, bawal naman ngayon nung nanlaban. So, talagang kailangan natin lakasan ang intelligence. So, kailangan mabigyan natin ng eksaktong funding yung mga law enforcement agency. At mabigyan natin, dapat isama natin dyan yung reward. Para may pang-counter tayo sa reward ng kabila, Mr. Chair. That is all, Mr. Chair.
Very nice suggestions coming from members of the House who both had LGU experience, no? Mga puro LCEs, no? Ng Iligan and Surigao del Sur. We would like to acknowledge the presence of Representative Bernadette Barbers of the 2nd District of Surigao del Norte. Now, since some of our authors are already here, can we just go over to, before I take the comments of the members of our resource persons, to the sponsorship speeches of the respective bills. No? May we now call on the author of House Bill number 74, Representative Bernadette Barbers of the 2nd District of Surigao del Norte.
Good morning, Mr. Chair. May I move that the explanatory note of HB 74 and 371 be entered into the records as my sponsor's sheet. Thank you, Mr. Chair.
Okay, the explanatory note of the will be entered as a sponsorship speech for House Bill number 74. We also have House Bill number 371, authored by Representative Richard Gomez of the 4th District of Leyte.
Okay.
House Bill 371 of Richard Gomez.
371.
Thank you, Mr. Chair. I received an information, Mr. Chair, that Representative Richard Gomez cannot make it today. I move that his explanatory note will become part of his speech, and I will read also his address this morning, Mr. Chair,
Go ahead, sir.
if I may. Mr. Chair, honorable representatives, invited guests, good morning. In the 19th Congress, this representation had the honor of spearheading the technical working group in which 12 House bills with proposed amendments to Republic Act number 9165 or the Dangerous Drugs Act of 2002 were thoroughly presented, discussed, deliberated, and resolved among concerned members of House of Representatives and representatives of various government agencies, including the Dangerous Drugs Board, Philippine Drug Enforcement Agency, the Philippine National Police, the Department of Justice, and others. This bill is resulting consolidated bill from the technical working group. The overarching direction of this consolidated bill is to strengthen Republic Act number 9165 drug prevention in the country by adding provisions that would enhance law enforcement. And the following are only some of the salient points of this consolidated amendments bill. 1. Inclusion of exportation of dangerous drugs in the roster of prohibited drugs. 2. Addition of more context to the definition of protector, cuddler, for all prohibited acts to include use of influence, power, or position to prevent arrest, prosecution, or conviction of violators. 3. Inclusion of provisions when violating entity is a juridical entity. 4. Reduction of quantities of illegal drugs and analogs considered as possession. 5. Stricter provisions on the use of dive, or resort in the conduct of illegal drug activities, especially in the identification of its financier, owner, operator, and cuddler protector. Next, provision for the proper disposal of confiscated items within 48 hours of seizure. Addition of imposition of higher penalty for alien offenders of RA 9165. Addition of provision of immunity to whistleblowers. And last, mandating local government units to allocate at least 1% of its budget for anti-drug abuse councils and supporting offices. To date, drug abuse and the drug trade continue to weigh down the country's socio-economic development. It is therefore imperative that our drug laws be amended to facilitate better implementation and effectiveness. In view of the foregoing, I humbly call for the swift passing of this bill. Thank you very much. That's all, Mr. Chair.
Thank you, Congressman Rehencia. For House Bill number 2756, authored by Representative Julius Cesar Vergara of the 3rd District of Nueva Ecija.
Mr. Chair, in behalf of Representative Julio Cesar Vergara, I would like to sponsor this bill House Bill number 2756, and I move that its explanatory note be considered its sponsorship. Can I please read the explanatory note?
Go ahead, sir.
This bill seeks to rationalize the penalty for illegal possession of dangerous drugs with a quantity of 1 gram or less, or marijuana of 100 grams or less, and for possession of drug paraphernalia, amending the Purpose Republic Act RA number 9165 as amended, otherwise known as the Comprehensive Dangerous Drugs Act of 2004. RA 9165 as amended penalizes all drug-related offenses, including the possession, sale, and use of dangerous drugs. However, current trends in combating drug use in other countries have shifted to rehabilitative measures instead of punitive ones. Drug users are viewed as individuals suffering from mental health issues who need medical and social intervention instead of imprisonment. This bill aims to introduce a more balanced and rehabilitative approach for first-time offenders caught with quantities of 1 gram or less for dangerous drugs and 100 grams or less of marijuana, to give them an opportunity to change and not condemn them at the first instance. The possession of drug paraphernalia is also decriminalized, while the penalty for possession of drug paraphernalia during social gathering is lowered with the same goal in mind. With this compassionate approach to drug use, the alienation of drug users will be lessened. The shame and stigma that comes with drug conviction is eliminated, and they would be more willing to admit and seek help from mental health facilities and their friends and family. The first step to reintegration as an active member of society is to create a society that welcomes them. This proposed measure also seeks to address the jail congestion issue. According to data gathered on September 30, 2022, 338 jail facilities nationwide are at 370% congestion rate capacity. There are 5 persons deprived of liberties, occupying 4.7 square meters of jail space. 68.59% of those in prison are charged with drug-related cases. These prisons are filthy and cramped, forcing the prisoners to live in squalor, which is not in accord with the basic human dignity. In this bill, if this bill is passed, law enforcement measures and resources shall be redirected to more serious crimes. Furthermore, the planting of evidence by law enforcement personnel will be prevented, since a larger amount of drugs is necessary for the penalty of imprisonment. The same goes for the planting of drug paraphernalia. In view of the foregoing, approval of this bill is earnestly sought. Signed, Julio Cesar J. Vergara, 3rd District of Nueva Ecija. Thank you, sir.
Thank you, Congressman Pimentel. We would now like to hear from the Philippine National Police. Sir?
To the chairman of the committee and other distinguished members and guests, good morning, sirs, ma'am. PNP, through the PNP DEG, fully supports the amendment of RA 9165, emphasizing the imperative of implementing evidence-based public health programs and advancing social justice in drug rehabilitation and treatment in the country. The PNP acknowledges the enduring menace of illegal drugs, which remains a driver of criminality, insurgency, financing, and social decay. However, the difficulties in prosecuting drug cases under RA 9165, particularly those related to compliance with Section 21 on the chain of custody, have undermined successful convictions and sometimes created opportunities for abuse and technical dismissals. These issues, as interpreted in jurisprudence, such as People versus Lim and People versus Sipin, continue to burden law enforcement operations. It is therefore imperative that any legislative amendment address these operational challenges, while remaining consistent with constitutional protections. The key issues and challenges that the PNP raises is on the rigidity of Section 21 of RA 9165, which resulted in numerous acquittals due to non-compliance with the prescribed chain of custody procedure. While intended to safeguard the integrity of seized evidence, strict interpretation by the courts has frequently led to dismissal of cases even when the illicit nature of drugs was not in doubt. The jurisprudence recognizes justifiable deviations, yet in practice these are narrowly applied and still require a detailed explanation by law enforcers, placing heavy burdens on arresting officers. We have other issues, but just to shorten our position, the PNP supports the intent of House Bill 74 to strengthen enforcement capacity, clarify presumptions of possession, and streamline custody and disposal of dangerous drugs. However, caution must be exercised to ensure that evidentiary presumptions do not unduly erode the presumption of innocence guaranteed under the Constitution. The proposed amendments addressing custody and immediate turnover of seized drugs to accredited forensic laboratories are particularly welcome, as they directly address the weakest link in the prosecution, the chain of custody under Section 21. These measures must be coupled with logistical support, including more forensic laboratories and trained evidence custodian nationwide. On House Bill 45, while PNP understands the deterrent rationale of reimposing the death penalty, it recognizes the broader constitutional, moral, and international law implications. The PNP takes the position that life imprisonment and heavier penalties already provided under RA 9165 are sufficient, provided that implementation gaps in prosecution and conviction rates are corrected. Rather than reintroducing the death penalty, the priority should be resolved procedural and operational obstacles in drug law enforcement. On House Bill number 50, the PNP fully endorses the commendation of the fisher folk and underscores the need to institutionalize mechanisms that reward and protect citizens who exhibit honesty and patriotism. Their voluntary surrender of illegal drugs without expectation of reward demonstrates the essence of bayanihan and strengthens the moral front in the anti-drug campaign. The PNP further recommends that Congress consider institutional incentives for whistleblowers and civilian informants under the Dangerous Drugs Board's framework. To conclude, the PNP reiterates its unwavering commitment to the fight against illegal drugs, guided by the rule of law, respect for human rights, and partnership with communities. The proposed amendments present an opportunity to correct long-standing weaknesses of RA 9165, particularly on evidence handling, without undermining constitutional safeguards. While deterrence remains necessary, the PNP emphasizes that the surest path to public trust and effective drug law enforcement lies not in harsher penalties alone, but in credible, consistent, and community-based implementation. The heroism of ordinary fisher folk stands as a powerful reminder that the campaign against illegal drugs is not only a law enforcement mission, but also a collective national duty. Thank you, sirs, ma'am.
Okay, thank you, PNP. Chain of custody, no, Section 21. This has always been the point of discussion, no? Kahit sa mga dismissal ng cases nyo, it's always Section 21. Even the issue on recycling of drugs, di ba? That has always been yan. I think that provision has been put in place to avoid siguro the temptation of having the drugs present in the wherever you put it in custody and recycling the same, and at the same time ensuring that the evidence to be used against the person accused is secured properly. Di ba? Walang dagdag, walang bawas, walang anything like that. But then, how is it parang ginagawang loophole ng iba eh. And I know that there are siguro challenges on the part of PNP in keeping strictly following the provisions of Section 21. Di ba? Tama po ba, PNP?
Yes, Mr. Chair.
And what part of the law would make it easier for you to siguro comply with the strict requirements of the chain of custody? Saan ba usually tinitira na nagagawang ground for the dismissal yung chain of custody na yan?
Mr. Chair, the ground of dismissal, especially with respect to PNP, is in the immediate marking and inventory at the place of operation.
And why is that difficult to comply with?
Sometimes there are reasons why the markings cannot be made in the place of seizure or arrest because of the dangers posed.
Because of what?
Dangers posed in situations where there are other companions of the.
So the PNP is incapable of handling that threat by providing more personnel, maybe backup ba or whatever. Ano bang ano?
Yes, we do, sir.
Let me
but-
understand. I'm sorry.
Yes. Yes, sir, we do.
I want to
but
better understand it, eh.
The interpretation of the law on immediate marking, even if we execute the same in 10 minutes, the case are still dismissed.
Why so?
That's the reasoning of the courts.
But you also understand the importance of immediate marking. Tama naman, di ba?
Yes, sir.
The need
Because-
for it to be incorporated in the law.
Yes, we
It's
need
also
to
required
keep the
naman. No?
integrity of the
Yes.
evidence. That's the reason why it should be immediately marked.
Yes.
But then it should not be a hard and fast rule. There should be if we are justified in marking the same within a reasonable period of time, then it should be accepted and not the only reason for the dismissal of cases.
NPL. Ikaw. Kayo yung nagpo-prosecute. So, ano?
Yes. Good morning, Honorable Chairman, and to the members of the committee as well as the resource speakers present today. Yes, indeed, we are one with the PNP in that aspect, Your Honors, Mr. Chairman, especially on the fact of marking. Though there seems to be, it is not actually an overturn of decisions, but there seems to be a conflict then of the decisions handed under the second division of the Supreme Court, starting with the cases of Tumawis down to Musor and others, as well as the clarification of the decision rendered by no less than the Chief Justice in the case of Tumabini. The problem actually lies insofar as the point pointed to by the PNP, Your Honors. The fact that there was no clarification as to the place or the venue of marking and photographing of evidence between those which were made through a search warrant and those which were made without a search warrant. Because, yes, it's true that if and when it is a bypass operation, then it is a planned operation, such that the danger of, say, for example, any untoward incidents may not occur, but there's a problem insofar as the issue on in flagrante delicto situations, or even hot pursuits, or even the stop and frisk situations wherein drugs are taken not really intended to be present during the time of the arrest. So in these cases, there is a problem as to the presence of the witnesses. such that supposedly in these situations it has to be clarified. Unfortunately, in the cases then decided by the second division of the Supreme Court, there was no clarification on the matter. Instead, they just declared, as if in totality, that the evidence taken should be marked and inventoried, photographed in the place where it was seized and was confiscated. There lies the problem as to the presence at the time, taking into account that we need to get still the presence of the witnesses on the matter, Your Honors.
And the law requires certain number of witnesses ba?
Yes, there are
Coming from different sectors, tama po ba?
Yes, Your Honors. And as a matter of fact, there was a decision, as pointed to by our resource speaker from the PNP, a period of 10 minutes, in fact, was then, a period of more than 10 minutes was declared to be no longer, in a sense, dignified enough to be called as in the performance of regular duties, Your Honor.
So PNP, when you were saying about the safety and security kanina, you were talking about arrests made in flagrante delicto or in hot pursuit. Now, where you are not in control of the situation naman, na nangyari lang na your police officer chance upon or something like that, no? That's the situation you're referring to. But not naman yung by bus na planned and properly supported.
There may be instances also where it happens in buy-bust operations, sir.
Ay mga ganun din.
Yes, sir.
But then, paano natin mabalanse po yung the need din to protect the accused from planting? Because whether you admit it or not, may nangyayaring ganun din eh. Di ba? Whether we admit it or not. Sometimes, siguro our enforcement agencies, sa gigil nilang mahuli yun, minsan they skip and they bypass rules eh. I don't know if you admit it, but I'm sure it happens. No? Isn't that rule also put in place to ensure that we do not do shortcuts? Sir.
Yes, Your Honor, if I may. Indeed, it's quite true, Your Honor. As a matter of fact, these procedures had been implemented by reason, of course, of what had happened in the past. And being in power for 17 years, I'm quite aware of these instances also. However, Your Honor, that's why being now in the prosecution service, I would say that there ought to be a clarification. Say, for example, if and when it happened through the so-called in flagrante delicto situations and others, then I do believe that law enforcement agents should be allowed to, in order to save also the time, law enforcement officers should also be allowed to bring the suspect, perhaps, and made the markings in the nearest barangay. Because everywhere you go, definitely, there is a nearest barangay which is available and has a duty elected official for that matter.
Okay. Anyone who would like to join in? Pidea?
Sir.
DOJ, sir? Yusek Andres?
Yeah. Thank you very much, Mr. Chairman. I just wanted to share that all of these issues could be approached in two aspects. First, simplifying the provisions of Section 21 to avoid unnecessary burden on the law enforcement agents and the prosecution in identifying the contraband and presenting it eventually in court after testing. This matter can be addressed with the modification amendments of the law. At the same time, we have this body we call the Justice Sector Coordinating Council. This is composed of the Department of Justice, the Supreme Court, and the DILG. In this body, we thrash out issues on the implementation of laws and the interpretations of the rules of court in relation to enforcement. And we are already able to address this. But I think the more important thing is to simplify Section 21, and that is part of the holistic amendments that we will present later on to the committee given the chance.
Thank you, sir. Pidea?
Sir, in addition to the concern of the Philippine National Police, our operating units in the PIDEA also find it hard to convince insulating or the required witnesses during the inventory of the confiscated drugs. To witness, sir. Kasi sometimes their contention, in the law, sir, there are two at least witnesses coming from the elected officials or the media or the DOJ, member of the DOJ. But in remote areas, sometimes we find it difficult to convince the elected officials or kung minsan wala pong makitang media personality o personnel that that will act as witnesses. So their reason usually are they will be required to attend the court hearings, yung expenses na magagamit nila, sir, and yung threats din na ma-experience nila during the prosecution of the case, sir.
Thank you, Pide. How about the Commission on Human Rights? Sir, do you have any opinion on the matter? Section 21 lang.
Yes, I think we have to, as mentioned by the DOJ, simplify such that maybe also unload the burden on the part of the enforcement officers, Mr. Chair.
Okay, thank you. Congressman Rehencia?
Ito po kasi yung sinasabi ni PD, talagang burden yun kasi nangangailangan ng mga witnesses pagkatapos takot dahil kung wala na sila, wala na yung operating unit, ang nag-witness, yun ang kakatayin doon sa mga suspects. So, ano ba talaga ang mano natin ngayon? Gagawin, PNP. Sa PNP. Kasi paghuli natin ng, kung gano'n ang palagi nating rason, pagdating sa kaso, dismiss lahat, wala, parang sabihan tayo, walang magawa yung pulis, walang magawa yung PDEA, kasi madali lang kaming makalusot, madali lang kaming makaalpas o mapiyansahan man lang dahil takot. Kulang tayo sa ebidensya, kulang tayo sa mga proseso, lalo na kung hindi na inventaryo kagad, wala na. At saka sa PDEA, naintindihan ko na kung mag-operate sa dangerous areas like, for example, Lanao del Sur, mayroong PDEA members na nag-operate doon sa Lanao del Sur, kakilala ko, sinuportahan ko, pagdating sa Lanao del Sur, inambush nung nag-operate sila, patay. 2 babae pa na agent natin ang patay. So with that situations, talagang, hindi na lang kami mag-operate kasi mamamatay kami. Mga ganong sitwasyon. So sa PNP naman, mag-coordinate tayo, PDEA at saka PNP, may proper coordination. Kasi kung magpatasan tayo ng ihi, lalo na ngayon, istrikto ang batas. Pagkatapos, kailangan, yung police hindi maka-operate without the clearance of the PDEA. Am I correct? Kailangan yung proper coordination. Huwag na yung, ako mag-coordinate tayo sa police, ang PDEA, masunog yung operations natin. Ang PDEA naman, kung mag-coordinate sa police, masusunog yung operations natin. Walang tiwala sa isa't isa. Katulad nung nangyari dito sa Ever ba yun? Nagbarilan. Nagbarilan ang police at saka PDEA, agents. Kaya ang gusto, kung sino ang maka-score sa malaking quantity ng shabu. Pero ngayon, hindi na ito, dahil ang mga shabu kasi, Mr. Chair, sa ngayon, parang yung information ko, sana i-confirm ito sa PDEA or sa PNP na niluluto sa high seas yung mga malalaking barko. With due respect to the Chinese people in our country, parang gano'n na nga. Yung na-display sa POGO operations, doon na lumipat. So, mayroon ba tayong mga, tulad ng sinabi mo, Mr. Chair, yung privilege speech mo, natandaan ko pa, mayroon ba tayong listahan sa mga taong na-display doon sa POGO dahil sa sinabi ni Yosek Gilbert Cruz, hindi na natin alam kung saan na yung mga taong na-display doon sa POGO operations. Lumipat na sila sa drugs operations. Malala na talaga ang problema natin sa druga. At saka, mas madali man siguro, PNP, mas madali, o PDEA, ang kukuha ng operations na mapin down yung mga suspects kung iano lang natin yung by bust operations. No? Mayroon kayong case operational plan, mayroon kayong implementing plan, mayroon kayong test by 3 times, saka ninyo by bust operations na talagang malaki na ang quantity na makukuha. Pero kailanganin ang budget, Mr. Chair. Kasi kung magbili ka lang ng 1,000, 2,000, walang mangyari. So kailangan dito millions of pesos, Mr. Chair. Magkano na ngayon ang gramo ng shabu? PNP. Magkano na ngayon ang gramo? O kilo ng shabu? Umabot na ng 6. Ngayon, hindi na kilo-kilo. Tuni-tunilada na ang ipalabas nila. Tapos, pagsabi, Colonel, PDEA, nag-operate kayo. Magkano bang sahod ninyo? Ikaw, Director, magkano bang sahod mo? 50,000. Ito, 10 million. Bigyan kita ng shabu. Bigyan kita ng shabu na 10 kilos. Hindi pa ba sapat yan? Kung nakulangan ka pa, sige, 1 tonelada. Wala na mangyayari, Mr. Chair. Kasi na-bribe na yung, sa sinabi ko kanina, na-bribe na yung mga law enforcement officers natin. So dapat, suportahan natin talaga. No? Iwan ko lang kung may papuntahan pa bang bansa natin. No? Kung hindi ito So, Mr. Chair, that's all.
Thank you. From the matrix naman po that we have, there are several proposals for amendments on Section 21, no? Which we will be waiting also for the proposals of the DOJ para ma-incorporate natin sa final output natin on the proposed amendments to 9165. But again, yung questions ni Rehencia kanina, is it an integrity issue or is it a coordination issue? So again, that's something that should be dealt with by the agencies concerned. No? So let's go to the National Bureau of Investigation. Sir, do you have a position paper on the matter?
Mr. Chairman, we have no opening statement, but we already submitted our position paper in support of the proposed amendment to RA 9165. With respect to House Resolution number 50, we believe that it is not enough that we acknowledge and we commend these people, the fisher folks, who surrendered the floating shabu that were found in the ocean. I think we believe that we should also hold a ceremony to honor their heroism in public so that we can showcase their heroism and to inspire the public to do the same. And of course, we believe that a monetary reward should also be given to these people.
Thank you for the comment, NBI. Now, Yusek Andres of the Department of Justice. Sir?
Thank you very much, Chairman and honorable members of this committee. We are very eager to support the work of this committee, as in fact, we wanted to share that more than a year before this meeting, we are already gathering important information, inputs coming from a multi-stakeholder consultation, which we call the Law Reform and Drug Summit, which we concluded last year. And we are now preparing the proposals based on the multi-sectoral consultation, and this will be ready sometime October. We appreciate all the proposed amendments to the bill that address the law enforcement aspect of addressing the drug issue. But nonetheless, we believe that the drug issue is a multifaceted issue, and there are many other aspects of the drug issue that needs to be addressed. So just allow me to give an overview and summary of the important factual antecedents leading to the conduct of the first ever Drug Policy and Law Reform Summit, which was sponsored by the Department of Justice, the Dangerous Drugs Board, the United Nations Office of Drugs and Crime, and including the UP Institute for Human Rights. So we take off from the State of the Nation address of the President in 2023, where he declared the new direction of our country's campaign against illegal drugs. The President said that the campaign against illegal drug continues, but it has taken a new phase. It is now geared towards community-based treatment, rehabilitation, education, reintegration to curb drug dependence amongst our affected citizenry. And likewise, during the 68th session of the Commission on Narcotic Drugs in Vienna, Secretary of Justice Jesus Crispin Remulla declared to the international community our country's statement on the new anti-illegal drug approach, highlighting a shift towards a more public health-centered and human rights-based approach. These are two important concepts that we will discuss in the course of explaining the insights and recommendations coming from the Drug Summit. Guided by the leadership of President Marcos, the Philippines has advocated for a human rights-based and public health-centered approach to drug control. Our enhanced Philippine anti-illegal drug strategy prioritizes health, social and developmental services alongside supply and demand reduction efforts. This comprehensive whole-of-nation approach integrates law enforcement, prevention, and public health strategies to create a balanced, unified approach. As we know, the bloody war on drugs in the Philippines, because of this, the United Nations Human Rights Council passed a resolution which provided for a 3-year technical cooperation and capacity building program on human rights in the Philippines. This is known as the United Nations Joint Program for Human Rights, or UNJP. The UNJP was aimed at facilitating technical cooperation and capacity building in 6 important areas, including the concerns raised by our congressmen on domestic investigative and accountability measures, data gathering on alleged police violations, and human rights-based approaches to drug control. This was implemented in July 2021 pursuant to the terms of the program. The present administration promptly initiated reforms to address these issues. We engaged different UN bodies through the Universal Periodic Review before the United Nations Human Rights Council, the 51st Enhanced Interactive Dialogue with the United Nations Office of High Commissioner for Human Rights, and the Revalida on International Covenant on Civil and Political Rights before the UN Human Rights Committee. And we reported the new administration's new policies and mechanisms which reaffirmed the government's resolve to take ownership of the national human rights agenda. This is important because the human rights situation in our country impacts not only domestic affairs, but also has significant repercussions in our dealings with the international community. So in April 2024, the DOJ, as I said, in collaboration with the DDB, the UNODC, Office of the High Commissioner for Human Rights, and the UP Institute for Human Rights, launched the Drug Policy and Law Reform Summit. Recognizing the complexity of the drug issue, the summit brought various stakeholders, including relevant national government agencies, local government units, policymakers, the academe, health professionals, former drug dependents themselves, addiction specialists, civil society organizations to discuss the drug issue and collectively craft a new roadmap. The summit consists of numerous multi-sectoral dialogues which convene no less than 402 stakeholders from all relevant sectors, including the youth, both students and out-of-school youth, the informal sector, both urban and rural folks, persons who have experienced treatment and rehabilitation themselves, the legal sector, drug rehabilitation practitioners, government agencies, LGUs, the women's sector, even indigenous people and persons with HIV and drug policy reform organizations were consulted. Regional dialogues were conducted throughout the country involving 11 regions. So this is the first time we have gathered information from the grassroots. And aside from these dialogues, we also called for the public to submit position papers, studies, and practices to share their experiences and recommendations on this new drug approach. So more than 20 organizations responded to this call. A total of 27 position papers were submitted and collated by the effort of the Drug Summit people. So after 3 months of pre-summit dialogues throughout the country, we completed the summit in July 2024. And this historic and ambitious effort successfully surfaced issues that are being raised by our members of the Committee on Dangerous Drugs, issues coming from the grassroots that enable us to see the drug issue from all angles, including the law enforcement angle, but also the socio-economic aspect of this drug issue and the public health approach that is needed to fully address the matter under the lens of human rights. A public health approach to the drug issue advocates for evidence-informed, tailor-fit, and holistic rehabilitation programs that will support recovery and reintegration. Law enforcement efforts will not be sufficient because, understandably, we need grassroots rehabilitation centers that will address the needs of the victims, that we understand this to be a health issue as well. To understand and address the root cause of the drug use, it must be contextualized in the circumstances of each individual, taking into consideration physiological, psychological, and socio-economic factors. And therefore, through the Drug Summit, it became clear that there is an urgent need for a new drug approach that is public health-centered and human rights-based. There is a strong call for a more balanced and nuanced policy that will incorporate law enforcement, prevention, education, and public health strategies and interventions. So following the Drug Summit, we were now in the point of doing focus group discussions and to fine-tune the proposed amendments to Republic Act 9165. And these amendments will reflect the insights and recommendations culled from the summit. There are 2 remaining days for us to do this, actually today, September 10 and September 29. And by the first week of October, we will be able to finalize and present the comprehensive amendments that we will submit to this committee for its reference guidance that will contain all the information gathered from the summit. Thank you very much, Mr. Chair.
Thank you, Yusek Andres. I would like to acknowledge the presence of our Deputy Speaker, Janet Garin, and of course, Representative Brian Poe of FPJ, Panday, Bayanihan, Party List. Yusek, tapos na yung summit niya?
The summit proper, the gathering of inputs is already completed, but we are now in the focus group discussions to discuss the details so that we can have a unified approach, consulting the national government agencies, the LGUs, the medical practitioners, the academe, so that all of the inputs will be harmonized. We are close to concluding this. We need 2 more sessions, which is actually slated this afternoon, and another one on September 29.
But this is the FGD na to?
Yes, sir.
All right.
Yes, sir.
So, is it okay if we send a representative from the
Yes,
committee,
sir.
COMSEC?
Most
Para at
welcome,
least
sir.
man lang, in the last few sessions, meron lang kaming doon.
Yes, sir. Thank you, sir.
And we will also wait for the outcome of your summit para ma-incorporate na natin in the proposed amendments para isang trabaho na lang. Yeah.
That's correct, sir. And because we are in possession of the proposed bills already that we were furnished, we are also harmonizing it.
Yeah.
And most of them are actually aligned with the findings of the summit.
So it's just the tweaking of certain provisions
Yes, Your Honor.
sa
Yes.
amendments.
That's correct.
All right. Based on the outcome also of your summit.
Yes, focus group discussions, yes.
Okay. COMSEC, can you recognize other resource persons present?
Thank you, Mr. Chair. Your Honors, we also have with us the representative from the BJMP, Jail Senior Superintendent Andrew Towley, and from the Bureau of Corrections, Attorney Neil Buot, the Chief Legal of Bucor. Thank you. Thank you, sir.
Thank you, Comsec. Any representative from the DILG? No, none. The Commission on Human Rights? Sir?
Good morning, Mr. Chair. Good morning also to the members of the Committee on Dangerous Drugs. Allow me to read the position of the Commission. The Commission, based on the documented human rights violations committed during the height of the war on drugs, believes that the state should consider adopting human rights-based and public health approach towards drug control. The intensity of the punitive implementation of Oplan Double Barrel did not result in the curbing of the proliferation of illegal drugs in the Philippines. Instead, the measure pushed the illegal activities sought to be curbed underground, making detection more difficult. The Commission likewise observed that higher penalties do not stop people from using drugs. The current mechanisms to curb drug use also need to be revisited in terms of effectivity, noting that while people who use drugs are forced into intervention programs, they lose opportunity to earn income for themselves and their family due to the mandatory 6-month period, if not longer. Based on the CHR conduct of monitoring visits to drug rehabilitation centers, there are findings that many government facilities do not even have experts on addiction science, as opposed to their private counterparts. The Commission therefore invites the committee to revisit the philosophical underpinnings of the overly punitive approach toward drug policy and refer to the discussions and learnings achieved during the Drug Policy and Law Reform Summit conducted by the government, led by the Department of Justice, Dangerous Drug in cooperation with Office of High Commissioner of Human Rights, ONDC, UP Institute of Human Rights, in partnership with civil society in July 24 and earlier. May I just read, I think Yusek Andres have it, but I'll just read the recommendations, Mr. Chair.
Go ahead, sir.
Number 1, refocus law enforcement and policing to target big organized crime groups. Reorient and capacitate our criminal justice sector players. Number 2, non-punitive approaches for drug use and low-level possession and sale. To consider decriminalization. Health and social workers as first point of contact, and law enforcers will be partners for referral. Number 3, develop comprehensive health, social, developmental services at the national and local government levels. Number 4, introduce public health-based responses that center on human rights in various settings like schools, workplaces, communities, jails, prisons, detention setting, health facilities, among others. 5th, jail and prison reform to have equitable health and social services and rehabilitation programs to ensure restorative justice. 6, develop alternatives to incarceration for drug cases involving use and low-level transactions. 7, accountability should be ensured for human rights violations, and victims must be given adequate redress and compensation. And lastly, number 7, law enforcement and judiciary members should be reoriented on health refocused approaches to substance use and low-level transactions, shifting the role from enforcement to support. We're happy that DOJ is already advancing on the recommendations in the previous drug summit. That's all, Mr. Chair. Thank you.
Thank you, Commission on Human Rights. First, before we recognize the author of House Resolution number 50, I guess we are very lucky that we have with us the presence of our former Secretary of Health, no? Deputy Speaker Garin, because most people have been talking about the drug issue being a health issue also. So I'm sure she has a lot of inputs that she could help us out with in the discussions. So now, Representative Brian Poe for the sponsorship message of House Resolution number 50.
Thank you, Mr. Chair and members of this committee. I'm very honored to be here. This is one of the resolutions that's close to my heart, if I may read it out. This is a resolution commending the honesty, integrity, and patriotic conduct of the local fisher folk of Pangasinan, Ilocos Norte, and Zambales for voluntarily surrendering packs of shabu found floating in Philippine waters. Napakahalaga po ang resolution na ito dahil pinapakita natin sa mga kababayan natin na buhay pa rin ang diwa ng bayanihan. Na kahit ordinaryong Pilipino po kayo, there's something that you can do to address the drug problem on your own. Itong mga fisher folk rose above the call of duty and were the ones who voluntarily surrendered these shabu packs in coordination with our local government officials as well as our uniformed personnel. This is a story which our kababayans across the country should hear and take note of. Narinig ko earlier sa mga members dito na hindi lang dapat commendation, dapat may reward sana ang mga kababayan natin na nag-voluntarily surrender po ng mga shabu or illegal drugs na nakita nila. This is to promote bayanihan across the country, to promote a sense of community. Kasi yung mga fisher folk na ito, voluntarily surrender po sila ng drugs because they knew the impact that it was having on their community. Kaya mga kasama natin dito sa committee, I move that we adopt this resolution subject to amendments from the committee because I do believe that they do need and they do deserve more than just a commendation. Sana we can also give them a reward for their heroism. Maraming salamat po, Mr. Chair, for giving me the time to speak on this matter.
Thank you, Congressman Brian Poe. From the National Prosecution Service, do we have one? Isaac Andres pa rin?
I also represent the
all
National
right.
Prosecution Service.
So same position most likely?
Yes.
All right. Thank you, sir. How about the Bureau of Corrections? Are they represented?
Yes.
Go ahead, sir.
Good morning, Your Honor. Sir, ma'am, good morning. The Bureau, may I read the position paper of the Bureau, Your Honor? The Bureau of Corrections supports the amendment of RA 9165 so as to respond and address the evolving drug challenges. Over the past 2 decades, implementation has revealed several gaps and outdated provisions that limit the effectiveness and fairness of the law in addressing the drug and other drug-related problems. RA 9165, otherwise known as the Comprehensive Dangerous Drug Act of 2002, was enacted to strengthen the country's stance against illegal drugs. It provides mechanism and prevention, enforcement, rehabilitation, and research. However, after more than 2 decades of implementation, the Act faces challenges requiring amendments to align it with contemporary realities, human rights standards, and public health evidence. Several provisions of RA 9165 that requires revision and position statement. Number 1, clarification of definition, for example, use, possession, pusher, to avoid vague or limiting interpretations causing enforcement in legal issues. The government should clarify and contextualize key legal definitions within RA 9165 based on empirical and practical insights that ensure fair and effective implementations. Number 2, removal of inconsistent and obsolete provisions such as residual death penalty clauses since the imposition of death penalty has been abolished under RA 9346. Any lingering reference to death penalty must be officially removed to eliminate public confusion and align printed and online copies of the law with current legal standards, considering that death penalty is no longer imposed in our jurisdiction. Enhancement of drug testing protocols to include comprehensive, scientifically validated methods beyond sole reliance on biological tests prone to false result. Increased support for rehabilitation and reintegration with expanded participation from families, communities, and local government units. Rehabilitation programs should be enhanced with more robust support and collaboration among families, communities, health agencies, and local government to ensure sustainable reintegration. Number 5, adoption of evidence-based and right-respecting approaches to drug-related offenses, moving from punitive to rehabilitative and preventive frameworks. The law must be amended to support a shift towards public health-centered drug policies instead of purely punitive approaches, incorporating scientific evidence and human rights framework. Finally, amending RA 9165 is essential to modernize the Philippine drug policy landscape. The amendments should focus on clarity, justice, rehabilitation, evidence-based policing, and public health approaches. Such reform will better protect the rights and welfare of individuals while effectively addressing the societal challenges posed by illegal drugs. Thank you.
Thank you, Bucor. How about the BJMP? Is there any representative?
Mr. Chair? Mr. Chair,
Congressman Rencia?
may query lang po ako sa Bureau of Corrections.
Go ahead, sir.
Bureau of Corrections, wala na ba pong mangyayari na mayroon pang mga kubol-kubol doon sa loob ng Bureau of Corrections?
Wala na po, sir.
Talagang naalis na lahat?
Yes, sir.
How about yung mga illegal drugs? May nakapuslit pa ba doon sa loob?
May mga pailan-ilan po, sir. Kaya hindi po talaga maiwasan eh. Nahihirapan talagang, nagtataka rin kami kung saan dumadaan eh. Actually, pati nga mga tao namin, grabe na searching namin. Ang dami na naming aso. Karamihan, nahuhuli namin sa babae. Sa ari nilalagay.
Doon talaga inilagay dahil mahirapan. Ma-charge mo kayo ng violation of human rights. Acts of lasciviousness. Kasi po, Bucor, no, karamihan, ilagay nila doon sa sandwich, doon sa pagkain, kung magdala ng pagkain, yung mga shabu para magamit doon sa mga addict.
Sa mga pagkain naman, sir, meron kaming dog na nag-i-snip na eh. Kaya marami na ring huli.
Okay, see. Thank you, Mr. Chair.
Mr. Chair,
Go ahead, sir.
dagdagan ko lang po, gentleman from Bucor. Nabanggit mo po kanina na hindi nyo masyadong nakikita alam kung paano nakakapasok doon, lalong-lalo na yung sa mga kababaihan. Siguro po, baka magkaroon po kayo ng proposed measures kung paano nyo maititigil yung mga kababaihan sa pagbisita sa kanilang mga PDLs, di ba? Ayun na, Mr. Chair. Sana pa magawan din po natin ng paraan yan.
Apo.
Thank you po.
So,
Thank you.
Bucor, if you have recommendations, can you furnish the office of Congressman Almario so he might study proposing or sponsoring that bill?
Yes, Your Honor, Mr. Chair.
Thank you, Congressman Almario. BJMP?
Yes, sir. To the Honorable Chairperson, esteemed members of the committee, ladies and gentlemen, good morning. On behalf of the Bureau of Jail Management and Penology, I express our gratitude for the opportunity to share our position on House Bill numbers 74, 371, and 2756, which seek to strengthen drug prevention and control and rationalize penalties under Republic Act number 9165. As the agency mandated to safely keep and rehabilitate persons deprived of liberty in city, district, and municipal jails nationwide, the BJMP directly experiences the operational impact of drug laws. A majority of our PDL population are charged with drug-related offenses, many involving small quantities. This reality has long contributed to congestion in our facilities, strained resources, and challenges in delivering rehabilitation programs. We therefore support House Bill numbers 74 and 371, which close enforcement gaps, professionalize case handling, and strengthen prevention, especially by integrating anti-drug education and schools. At the same time, we strongly support House Bill number 2756, which rationalizes penalties for possession of 1 gram or less of dangerous drugs, 100 grams or less of marijuana, and paraphernalia for personal use. By directing these cases toward proportionate, health-based intervention instead of custodial penalties, Congress can ease jail congestion, reduce unnecessary detention, and allow BGMP to focus our facilities on high-risk offenders while supporting community-based rehabilitation for low-risk users. Thank you very much, and we assure this committee of the BGMP's full cooperation in advancing these important reforms.
Thank you, BJMP. Congressman Almario?
Mr. Chair, the gentleman from BJMP, I would like to ask some question also.
Yes, sir.
Katulad po nung natanong po kanina sa Bureau of Corrections, kamusta po ang status naman ng drugs po doon po sa atin sa mga BJMP po? Kung may nakakapasok pa rin po ba sa inyo?
Actually, mayroon pa rin nakakapasok. Isa rin sa mga dahilan kung bakit may nakakapasok ay through sa ating mga visitors na mga babae. Sa private parts din po nila nilalagay. At saka kalimitan kasi ang ating mga situation ng jails located sa mga communities. So mayroon pa rin naghahagis from outside, hinahagis nila inside, tapos doon kinukuha ng ating PDL, pero kalimitan sa mga yun ay na-intercept ng ating mga personnel.
Maraming salamat po.
Thank
Thank you, Mr. Chair.
Mr. Chair,
Congressman Rehencia?
tanong ko lang po sa BGMP kasi alam siguro ni BGMP nung I was once incarcerated for 1 year, 3 months, 18 days, 2 hours and 47 minutes, 36 seconds sa krimen na hindi ko ginawa. Na-charge ako ng, binilang ko talaga yon. Na-experience ko yon sa Iligan City Jail. Mayroon talagang magkapasok. Lalo na doon sa tinawag niyo mga babae na inilagay doon sa ano nila. Pero mayroon naman tayong personnel ng mga babae. Hindi ba natin ma-correct yun para maiwasan ba? Doon pa lang sa kulungan, makapasok ang druga. How much more kung doon na siya ang drug dependence doon na sa tinawag nating bahay silangan. Kasi mayroon kami noon sa Iligan, yung bahay silangan. Kung sa jail, makapuslit sila, paano na lang kaya doon sa bahay silangan? Ano ba talaga ang kulang ba ng personnel ng mga babae para mag-inspeksyon sa mga babaeng dalaw para hindi talaga makapasok yung druga?
Tama po kayo. Mayroon pong instances na ganun na talagang may nakakapasok, pero mayroon po tayong ginagawa ang ating po mga personnel na babae, sapat po naman para mag-inspeksyon sa mga dalaw na mga babae po.
Yung tinatawag ninyong Operations Greyhound, ilang bisis ba sa isang linggo kayo mag-conduct ng Operations Greyhound sa loob ng kulungan?
Sa Operations Greyhound, pwedeng as much as the warden can do so, pwede silang mag-Operation Greyhound anytime. Lalo na sa mga intel driven kung na may nasagap na intel po tayo sa labas na mayroong magpapasok ng droga, yun po.
Thank you, Vice Chair Rehencia. We'll now call on the KBP.
Good morning, Honorable Chairperson and members of the committee. The KBP wishes to convey its thanks for the invitation for us to participate in the deliberation on the proposed amendments to RA 9165. Specifically, the KBP wishes to support the amendments to Section 21 that removes the requirement for a member of media to be a witness and to sign the inventory of drugs confiscated during a arrest or an operation. These requirements unnecessarily exposes the members of media to risk and affect their objectivity in the proceedings. That is all, Your Honors. Thank you.
Thank you, KBP. I think the requirement that media personnel, the mandatory requirement has already been amended by Republic Act 10640. No? It now becomes optional. Optional ba? Yeah. Yeah.
Thank you, Your Honor.
How about National Prosecutors League? Sir.
Good morning, Mr. Chair, once again, and to the members of the Honorable Committee, as well as to the resource speakers and participants of this hearing. Yes, sir, in deference to the DOJ, of which we are subservient to, as well as taking into account that, as have discussed, been Yusik Andres, it would be a comprehensive report on the several meetings as well as consultative hearings of in relation to drugs. We in the Prosecutors League of the Philippines, however, would wish to manifest our full support as to the proposed amendments of Republic Act 9165, especially on the issue of rationalization of the penalties. This facts actually goes in line with the program of both the DOJ and the AC, especially on the plea bargaining program and system implemented in those cases wherein only minute drugs had been confiscated. Second to that, Your Honor, we are, of course, hoping and looking forward to the amendment to be introduced in Section 21, especially on the issue of the time stamp or the date wherein it could be seen when the accused was actually arrested, taking into account that, yes, with all due respect also to our law enforcement officers, there were times when, in fact, suspects or accused had been arrested way earlier than what has been reported or contained in their affidavits. So in that regard, the putting of the timestamp would be really very effective. Second to that, Your Honor, there is an issue, of course, as to the inclusion. As a matter of fact, that is the law that we've been following now, where the prosecution or the NPS was, though not mandatory because of the presence also of the media, but it is the prosecution who were required or are required to be present as an insulating witness. However, taking a step back and taking into account also that in the Constitution, a suspect or accused is necessarily been given a counsel whenever he has been accused of any crime at all, and considering also that as of now, that the duty of the prosecution is no longer in fact quasi-judicial but investigative, to avoid the so-called issue of impartiality, perhaps a look on the possibility of it should be the PAO who should be taken as an insulating witness. Because at the very start, they could not protect the rights of the suspect and accused. Second to that, it may appear like the law enforcement officers and the PAO may have a conflicting role to speak of, but this would also, in a sense, make the law enforcement officers or agents mindful of how they conduct the operation. Because all of these things, the complication came out by reason of what had happened in the past. So definitely, there is a need to look at it again. Also, Your Honor, that's why I have said a little while ago that there is really a need insofar as the issue on clarification of the kind of arrest or operation, taking into account the difference between a search warrant, the buy-bust operation, as well as the in flagrante delicto doctrine, the so-called hot pursuit, and the stop and frisk. Now, we have also prepared a proposal on that aspect. And most and foremost, I would say we are so thankful that unlike on the previous proposal, there is now a change insofar as Section 92 is concerned. That is bungling. Because definitely, hard as it may seem, but we prosecutors and in fact law enforcement agents really are in deep worry insofar as the kind of proposal before. As a matter of fact, most or many of our prosecutors who are assigned in drugs court, they are often begging us to not assign there anymore because of this issue on bungling. Now, perhaps the only thing that I am more particular of also are some provisions in the proposed bill which went to the point of the presumption of guilt rather than innocence. This indeed is quite contrary to the Constitution, and as a matter of fact, shifted the burden. Because under the law, as we have heard it, and practiced in our society, it is the prosecution who has the burden of proving the guilt of the accused. In fact, the accused has the right to remain silent. However, in some provisions, there already were provisions which take the presumption of guilt and obligated the accused to explain. So in that regard, perhaps these are points that needs to be reconsidered also, Your Honors. Thank you.
Okay, thank you, NPL. NPL lang, matanong lang, no? Kasi ang problema ni BJMP is congestion eh. And sabi niya, karamihan ng detainees nila, drug-related. And most likely, they will point out to you na because of the length of time that it takes for the case to prosper in the courts, that's why they're congested. What is NPL doing about it?
Actually, Your Honors, we are cognizant of that. And as a matter of fact, Your Honor, we too are really are finding ways to expedite. Kaya, that's why I am quite happy also in one court in the Votas, wherein I have not even seen a trial lasting more than 3 months. It was quite very expeditious, Your Honor. Though there's just so many, the number of cases, Your Honor.
But that's the exception rather than the rule, ano? Yung 3 months na. Yusek Andres.
Yeah. Allow me to inform the committee about institutionalized reforms that we have put into place to address jail congestion. First, when we issued Department Circular number 20, which is the proactive case buildup of cases, we at the same time increase the threshold of evidence needed before a person can be charged in court. No longer will it be probable cause, which was the practice before. It is a higher threshold, which is prima facie evidence with reasonable certainty of conviction. Because of this, maybe half of the cases are filed instead of 1,000, maybe just 500 cases. But out of the 500 cases we filed, we have 93.9% conviction rate. So that is better. On the part of the Bucor, we have already launched a digitization of prison records. Isa pang naging reform po yan kung saan dati hindi natin alam ang eksaktong panahon na napagsilbihan ng isang person deprived of liberty, but now we have already completed 100% digitization of all the prison records. And therefore, no one will stay a day longer than is necessary to serve their prison sentence. At sa katunayan po, mahigit 8,000 people ang napakawalan namin dahil lampas-lampas na po pala ang paninilbihan nila sa kulungan at nandun pa rin sila. It saves the government a lot of money because they should not be there, and now we are expediting the processing of the release. Napakabilis na po ngayon.
Okay. Now, I have a question for BJMP lang. BJMP, anong average period ng detention ng tao before the cases are resolved, drug cases are resolved? Average lang.
Depende po kasi sir sa sa bigat po ng kanyang kaso pag sa
depende sa mga sections na
So mag-matter pa anong section ng na-violate niya? That shouldn't be the case, di ba? NPL?
Your Honor, sometimes, Mr. Chair, it matters very soon of the number of witnesses presented.
Oh, number of witnesses. But
Yes.
not the weight or what
Yes,
section
Your
is
Honor.
violated, di ba?
Yes, Your Honor, as well as the availability of those witnesses, Your Honor, though courts are quite strict as of now. And we
Okay,
defer to-
but BJMP, anong average? A year, less than a year, more than a year, or ano?
actually we don't have data
you
on
don't.
average
Okay.
because yung those filed cases to our PDL are sometimes depending on the sections. There are sections that that requires punishment of low, and there are there are sections that
Drug cases na
requires
itong tanong ko eh. My
penalty
question
of
is
fine.
just on drug cases lang.
If they are given a chance of play bargaining,
Okay.
these
Then
are
faster.
cases below the penalty is below 6 years and below. They have of course short.
Yes, because they take that plea, no?
Yes.
Okay.
Yes, sir.
Isaac Andres?
Yes, can I just add the information that based on the new approach, we are expecting more plea bargains because at the start of the trial, upon arraignment, the accused is already confronted with the complete evidence that is facing him. And that is why he has no choice either to admit to the offense or go to a protracted trial. But with a plea bargain, he can get a lighter sentence. And that is probably 80% of the conviction rate is based on plea bargains. And the few that go to the entire trial, probably we can say the quickest is 3 months and probably the average is a year.
Okay, Yusek, you mentioned earlier about the digitization, no?
Yes.
Which led to the release of those who have served more than what was their sentence, di ba? We had one witness kasi sa Quadcom before na si Andy Magdadaro and he supposedly has already served his sentence but he's still currently in jail until now eh.
We can look into that particular
yes, can you
instance,
please look
sir,
into
but
it?
the only possibility is
Other cases?
Yes, he may be being held not only for one case but for several cases.
But digitization should also clear that up, di ba?
yes, sir. Yes, sir.
All right. Sige. Thank you.
Mr. Chair?
Vice Chair Hensha?
Mr. Yusik, sir, mayroon lang po akong naobserbahan doon sa field na yung plea bargaining agreement ay inaabuso sa mga natin yung mga akusado dahil kung pakawala natin sila dahil inamin nila, bumabalik din sila paggamit ng droga. Ano po ba ang natin dyan? Dahil sa plea bargaining agreement doon, ipasok sila sa bahay, bahay silangan. Pagkatapos maano na sila, mapakawalan, maobserbahan din natin sa mga kapulisan natin na bumabalik, gumagamit pa rin sila. Minsan, nabibinta pa. So ano pong paraan natin dyan para hindi gano'n na mataas nga ang natin pero bumabalik naman yung mga tao na gumagamit ng droga?
Tama po, Mr. Chairman, yung obserbasyon ninyo. At minsan nga po naabuso yung plea bargain option. But we are trying to address that matter here in the new law that we will submit as part of the amendments because the severity of the affliction of the person using drugs should be assessed. Meron pong tinatawag na severe, may moderate, merong light po na severity. Pag yung severe po, doon po talaga dapat magkaroon ng mandatory rehabilitation. But for the light offenses, hindi ho kailangan eh. At yun po ang magkakaroon ng distinction. Kakaunti na po yung makukulong sa mandatory manner of rehabilitation kapag na-inject natin yung proseso of determining first the severity so that the judge can appropriately make a recommendation whether for this particular case, sufficient na yung mag-outpatient ka na lang. Pero dun sa mga severe cases, kailangan 6 months po kayo mag-undergo ng rehabilitation.
Mr. Chair? So with that process, Yosek, malutas na natin yung problema sa BGMP.
Correct.
Dahil yung congestion, makalabas, mababawasan na yung mga tao nila, makatipid rin tayo ng pera.
Tama po yun. If I may just introduce this concept now, part of the insights of the Drug Summit is the concept of decriminalization. Hindi po ibig sabihin, hindi natin paparusahan yung pong gumagamit ng droga, but we are finding ways of alternatives to incarceration, and diversion is one of it. Imbis kayo ay makulong, parehab na lang muna kayo, pumunta kayo sa rehabilitation center, mag-attend po kayo ng session sa psychotherapist, and that will declog the jail system as well.
Mr. Chair, siguro, para naman, nandito naman tayong lahat, so mga amendment natin, ipasok natin.
Opo.
Maganda siguro nga, kung naka-appeal na yung tao, tapos inaabuso niya yung privilege niya, kung mahuli siya ulit, wala nang maraming hearing. Ipasok na balik doon sa kulungan dahil inaabuso niya eh. Sana mano natin yan stipulated natin doon sa amendment kasi para makatipid rin tayo ng panahon, makatipid tayo ng gastos, at saka kung hearing pa, dami pang postponement, kaya tumagal doon sa kulungan. Minsan nga, yung pagkakulong niya, 10 years na, o 5 years. Tapos sa sentensya niya is only makulong siya 3 years. So lumampas na ng 2 years. So ganon siguro ang natin, hindi naman tayo siguro violating the human rights kung ganon. Kung binigyan na siya ng pagkakataon, pagkatapos pinakawalan, bumalik uli, wala nang hearing-hearing yan. Pag mahuli, pasok na yan sa kulungan.
Tama po yun. At meron pong mga rules that apply to that. Yung tinatawag po natin na recidivist, paulit-ulit po na offender. At pag yan po ay pangalawa o pangatlo na, ay hindi na po siya qualified mag-plea bargain. Kaya hindi po tayo pwedeng madoble na labas ng labas.
Thank you, Yusik. That's all, Mr. Chair.
Thank you, Vice Chair Rehencia. Isang issue lang na I also want to discuss, no? Itong disposal, no? How do you dispose of the drugs, and sino ba ang siguro prime agency, no? It's either PIDEA ba or PNP na who has the obligation of disposing the drugs? PIDEA. All right.
Yes, sir. Your Honor, once we receive the order coming from the judge, that is the time that we prepare our destruction procedure. We first secure the court order for destruction, take the pictures of the evidence. Of course, we are going to reweigh the evidence, re-examine the evidence, take representative samples pursuant to the provisions of Board Regulation number 1, series of 2002, then burn the dangerous drugs using thermal method, sir.
Kasi I'm asking that, sir, kasi the issue on recycling and of yung nawawalang droga while in custody, matagal na to and still present now, di ba? So, anong gaps dito that we can plug in the amendments of the law para sigurado tayong there's no chance of recycling it, there's no chance of diluting it ba or whatever, no? Para at least sigurado tayo that what has been seized is immediately destroyed as soon as possible ba?
Your Honor, sir, on the part of PIDEA, we make sure that no recycling is made because there are measures being undertaken, like the installation of security measures, like the CCTV cameras inside the evidence room, and other measures, sir. But with regard to the immediate destruction, we really adhere to the orders or order coming from the court for the disposition of the said drugs, sir.
Yusek Andres?
Yes, Mr. Chairman. We were discussing earlier the issue on chain of custody, and this is a related matter. For our purposes, in order to effectively prosecute, I think the integrity of the process should just be proven. Meaning from the time of the arrest of the law enforcement agents to the delivery of the goods to the testing and eventually custody before it is submitted to the court. Once that is already fully documented, this particular substances should already be destroyed. But presently, the system is that the courts are still requiring the physical presentation of this contraband. But eventually, if we are able to amend the law, then it will simplify everything. After the arrest, after the inventory, after the chemical testing, we can immediately destroy.
But sir,
So that we just document it and make it part of the real evidence, object evidence, to be marked and eventually submitted in court.
Is it a requirement under the law that you have to present the entire
Yes.
thing? Huh?
It is real evidence at this point in time under the state of the rules of court and the present state of the law.
So-
But that is part of the amendments we are trying to propose.
So, example ng situations, like example, yung isang toneladang nahuli. Di ba? So, it has to be physically brought to court?
Hindi naman po, sample yung iba. Pero there are instances where the court will schedule an ocular inspection.
Ocular, okay. Can't they do it early and then dispose of it as soon as possible?
I think that's the right amendment to the
Kasi
law.
the less that we have in our custody, the easier it is to say na walang recycling nangyayari sa PNP, sa PDEA, and then all other agencies. Wouldn't that be correct, sir?
That's correct, and that will address the issue if we put it as part of the law itself.
Yes, sir. Kasi diba, it's also expensive on the part of PNP to be creating facilities just to hold these things, eh. Di ba? Tama ba?
Yeah, Mr.
PDEG. Sec.
Yeah, Mr. Chairman, mahal din po pati yung pag-distract ng confiscated or ng seized. Yeah, it's umuo pa ang PIDEA ng facilities para yung huling distraction sa Tarlac.
Sir, can you speak into the mic? I cannot hear you po. Sorry.
Mahal din po yung pag-distract ng ang PIDEA nang-uupa ng mga private facilities for the destruction of this.
So destroying it is expensive, keeping it is expensive. What should we do with it?
Mr. Chair,
Vice Chair Rencha.
yung magbayad pa kung susunugin yung druga.
Opo, nagbabayad po sa private facility.
Sa amin, sa Iligan City, nag-coordinate lang ako doon sa gumagawa ng simento. Doon natin sinusunog yung mga shabu. Wala nang bayad.
Mr. Chair,
Congressman Pimentel.
I am with the observation of the gentleman that we should amend the law. Like in the US na basta may certification na pinakita na sa judge, sunugin ka agad. Kasi ang nangyayari dyan, kaya nagkakaroon tayo ng recycling, wala naman akong pinagbibintangan, habang tumatagal sa custody, kahit anong agency, may nangyayari. Yun yung perception ng mga tao. So, siguro, again, I would like to reiterate na we should amend the law. Na pag pakita na sa judge, may certification, diretso na sunog. At magkaroon tayo ng sariling facility na magsunog. Kasi yung private, hindi natin alam. Bigay lang natin doon sa private. Kung kalahati lang yung sunugin nila, yung ibabaw lang. Thank you, Mr. Chair.
So the longer it stays in custody, the more tempting it is on the part of the agency. So any other points? Congressman Almario?
Mr. Chair. Since wala na po ata tayong mga resource speaker, as regards to the House Resolution number 50, authored by our distinguished gentleman, Representative Brian Poe, I move to include the giving of reward to the concerned fisher folks, Mr. Chair. Thank you very much.
Okay. Thank you, Congressman Almario. Is there a second to that? Is that a motion?
My motion is to move to include the giving of rewards to the fisher folks concerned.
Any second? Duly seconded. Any objection? There being none, then the motion is approved. To include in the resolution the request that the reward be also be given.
Yes, Mr. Chair. Thank you so much.
Congressman Mario. Any other matter that any member would wish to present before this committee?
Yes, Mr. Chair. I move that all members of the committee present in this hearing today be treated as principal authors of the measures considered today.
Second, Mr. Chair.
Okay, so it has been moved and seconded that the members present today be included as authors in the House bills filed with the conformity of the sponsors. Okay, they agree. So the members present will also be considered as authors of the bills filed. Any other thing?
I move to adjourn
Okay.
the favorite agenda.
So all right. So before we adjourn, I would like to direct the COMSEC not to prepare the report on the bills that we heard today, including the resolution, HR 50. It has been moved and seconded that we adjourn. There being no objection, then the meeting is adjourned. Thank you, everyone.